Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and once again we with us our partner Mr. David Nachman. David,
Thanks
welcome.
so much, Michael. Always a pleasure, of course.
So before we start today's program, I'd like to wish something to our viewers. दिवाली का अवसर है, तो इस दिवाली के शुभ अवसर पर आप सभी लोगों को दीपावली की शुभकामनाएं, आपको और आपके परिवार को। आप एंजॉय कीजिए, दीप जलाइए, मिठाइयाँ खाइए, सेलिब्रेट कीजिए और हमको भी याद कीजिए। And with this, David, you want to say a few words also?
So I would just like to wish all of our viewers, as we do every year, a very happy Diwali holiday. Enjoy the lights, the Festival of Lights, enjoy the sweets, and of course enjoy the time with your family. This is a very sacred part of the year for everyone, and we hope you really enjoy. And it's actually a really nice part of this year because we're going to be flowing from the TNEC International Film Festival, which the NPZ Law Group has a very, we play a very big role each year. And this year, Ken Nas from Eros International has been gracious enough to allow us to screen an excellent movie called, Michael, it's
Dil Dhadakne Do. Say that, say that.
Dil Dharakne Do.
Good.
Ooh, okay. And so
Okay.
we're going to be screening that actually on Friday, November 6th. And of course, we invite all of the folks who were there to enjoy the weekend of many, many films. As Michael explained, we have several different sites set up where we're going to be showing many different movies on Saturday and Sunday. So make sure you go online to the TNEC International Film Festival, buy your tickets, and enjoy the event with
Now you
us.
can buy the ticket for the entire 2 days program or just for the movie.
And it's a nice way to usher in Diwali, so it's really nice. Yeah. So, so with that, Michael, I think we wanted to talk about the new memorandum, which is out there. It came out a couple of weeks ago. Yeah. Please. Yeah. Absolutely.
We are going to talk today about the waivers. Now, what is waiver? People say when we tell them that I think you are ineligible because you might have committed a crime, you might have health reasons, because there will be so many different grounds based upon which an American consul denies the visa. And one of the common is 212A6C, under which if a person has lied, misrepresented fact, or committed a fraud, or give fraudulent documents, any of those things, or smuggling, require a waiver, but the availability of waiver is based upon certain conditions. So today's program, we're going to talk about the waivers generally that I just mentioned, and the basic requirement basically is the person that is applying for the waiver should have a parent, a citizen holder or green card holder parent, or a citizen or a green card holder spouse, not the child. The child used to be for many years, child was one of the reasons. So that process is not as easy as people think. We had cases where a person, consuls do their own job. They say, oh, so you need a waiver? If you want a form, we give you a form. That's it. So he goes home, fills up the forms and mails the form. What will that do, David? He goes home, consul told me, fill up the form and submit it.
Right.
And he goes and send a check. So why shouldn't he get approval?
Well, that's not what it is. It's not about just filling out a form. It's about making your case. And that's what the case for extreme hardship is all about.
It says extreme, the word extreme hardship, not simple hardship. Because you say, oh, I'm separated from my wife. That may be a hardship, but that is not extreme. So extreme has always been an issue. And believe me, I'm telling you, my theory about a waiver application is putting in all the documentation, maybe the psychiatric reports, medical reports, and anything that will make the officer have a drop from his eyes. He should really emotionally, an officer reading that, say, oh my God, this guy really deserves it. So that takes a big effort. It's not easy. I mean, basically that's why. So that has been a good thing. But there we see still a lot of cases were denied because they were not able to meet the requirement of extreme hardship. So now David is going to tell you about a memo what that memo says and how that would help some people that who were previously not able to get a waiver.
Well, I think one of the most important things for us, for everyone, for our viewers to understand is that back in November of 2014, President Obama announced a series of executive actions. And among those executive actions, if you recall, one of those was to give more objective methodology or more transparency to the interpretation of what is considered to be extreme and unusual hardship. So what they did is they promulgated a memorandum a couple of weeks ago, and in the memorandum what they've done is they describe which waivers require a showing of extreme hardship. They also explain, of course, that extreme hardship is more than just an analysis it has to do with what's called aggregation, or I refer to that as a totality of the circumstances test, where it doesn't just have to do with one particular thing, but it has to do with a set of many things that could be deemed to be unusual hardship, extreme hardship. It also explains that hardship has to be great suffering or loss, and that the hardship has to be greater than that which is usually encountered as a result of the denial of admission or removal, which is actually what Michael was saying before. And it also clarifies that extreme hardship depends upon individual circumstances of each particular case. A lot of times when clients come in to talk to us about waivers, they think that their case is like their friend's case. This is really...
My cousin got, my brother got, why you are not getting for me?
Exactly. This is an incredible example of the fact that each case is, it's not cookie cutter at all. Each case stands on its own merits. So a case which applies to, your friend doesn't necessarily apply to you, because the facts and circumstances of your case are going to be different than those of your friend's case. Also, what's interesting about it also, the memorandum goes very far to explain that there are special circumstances which apply to, and what they do is they actually break out what are called hardship as a result of relocation and hardship as a result of separation. And then what they do is they say, is it foreseeable that your spouse or your family member will relocate? And then you have to show whether or not it's foreseeable that separation will occur. So this memorandum in a way, what it does is it gives more objective methodology. I have to say that in my review of the the memorandum, I didn't see anything that really was so incredibly different from what we were already used to in terms of extreme hardship, because what we always do is we try to show as many possible prongs of extreme hardship as possible. But for many people who don't do things the way our office does, maybe this was new and burgeoning, because what it does is I think it really hammers home the importance of trying to show this extreme hardship on every single prong. It actually gives, the memorandum lays out a very nice chart. And in this chart, what it does is it goes through all of the items. For example, it talks about health conditions, it talks about country conditions, it talks about a variety of methodologies that can be utilized by the person whose economic impact. So it goes through and discusses all of the potential options. So what it does is this memorandum actually sort of in a way brings together all of the case law, all of the cases out of the BIA, and brings it together into one nice guidance memo. And I believe that when this is approved, it probably will become part of the USCIS policy memorandum that are used by adjudicating officers. So at least what this does is, and by the way, this is just a draft right now. There will be comments, exactly, and the comment period I believe is open until the end of November or thereabouts. It's actually the comment period will close on November 23rd. So the public is allowed to submit comments to the government on what they believe to be what is fair or unfair about this memorandum. Please, Michael. Yeah.
The problem always has been the word extreme, but Obama has been coming with administrative memos in different ways somehow to make it easier. Now, Obama cannot change the law. He cannot take the word extreme out. He cannot take it out. That's the statute. The question here is, what constitutes extreme? What does it mean exactly? What is really required? What does it mean? Extreme what? So basically, I think it's a matter of interpretation. Interpretation can be done by anybody. Oh, administration say yes, extreme, but we think this, and this, and three things, four things constitute extreme.
Exactly.
So this is what exactly the memo does. Is okay, and then you have to be also smart. I tell you what, somebody said the woman wife is here, husband is stuck in India because of this 212A6C ineligibility, and this lady has 2 children. Now children are born US citizens, but they are not in the rule. So what we show, you have to come around, like say, okay, this woman cannot take care of the children. She is under extreme hardship because 2 little children, she cannot take them for games, she cannot do. She needs a husband to help her in her extreme hardship, right? So it's directly you cannot say the children citizens are extreme hardship. It is the mother who is the extreme hardship because of the children. So there are different ways. Listen, a mother, somebody's mother is here, green card holder, common cases. The son is in India, stuck, right? So of course there is a parent, she is eligible on that. But question is, how do you show extreme? I ask the person when he comes in, the mom, mother, are you really depressed because your son cannot come? She says, yes, of course, I cannot sleep in the nights, I get bad dreams all the time. She starts crying. I can see that she really is depressed. I say, listen, in this kind of case, it's maybe a good idea for you to consult a psychiatrist or psychologist and get a report as to how this is affecting your life and mind.
Exactly, and our office works with mental health professionals who are qualified to give expert opinions about whether or not there is this extreme hardship.
So this is very good, because this, in a way, directly or indirectly, eases up a little bit at least to meet the extreme hardship requirement.
Exactly. Now, with regard to aggregation, what they also said, again, that's totality of the circumstances. This memorandum makes it clear that it doesn't have to be, you can actually prove extreme hardship. Even if you have a non-qualifying relative, you can use the hardship to the non-qualifying relative to prove the hardship, but you still have to have a qualifying relative. Right. So, but there could be a hardship to a non-qualifying relative, and that could be something that is used to prove extreme hardship. They also, in this memorandum, which I think is the most valuable piece of it, they talk about special circumstances that, quote unquote, strongly suggest extreme hardship. And in the memo, they point out, 1, qualifying relatives previously granted asylum or refugee status. 2, qualifying relatives or related family members' disability, and the disability, they say, could be determined by a U.S. government agency. 3, qualifying relatives' active duty in the military. And 4, the Department of State warnings against travel or residence in certain countries. 5, substantial displacement of care of applicants' children. Okay, and let's see. Yeah, and so those are 6 of
the one I said, care of little children.
Exactly. Right, exactly, you were right on. But what's really interesting, these 5 points are what they consider to be indicia of extreme hardship. And so it's very good. So they're not saying that if you prove one of these, that you're going to get it. But what they're saying is, these strongly weigh in favor of a finding of extreme hardship.
And I tell you, no matter how much we do on the TV, which is a good idea, but when you actually want to apply for a waiver, it's a lot of articulation. The manner in which you present the case, you explain the case, you give the documents to satisfy the officer who's making a decision that yes, he is in mind. He's reading and says yes.
Right, certifications, letters, reports, tremendous amount of paper, photos, exactly, tremendous amount of
medical reports, everything, whatever we can put in, make a solid case that you win. Winning is the most important.
Exactly. So the ultimate test, I think, in how this memorandum is going to be, the value of it, of course, is going to lie in what the final guidance looks like, because we're not going to know that until after November, and then finally how it becomes implemented by the adjudicating officers.
So let's pray God this will be nice, sir, will be very helpful, and we really thank you very much, David, for coming on the program.
Thanks so
Thank all of our viewers for watching the program.
And
Please,
happy Diwali.
happy Diwali again, and keep watching us every Saturday and Sunday at 11:45 a.m. Thank you. Bye.
For now.